Hello, everybody. Good to see you guys. Yes, we meet again. So happy to have you. Hello, Emily. Mika 511. We need to keep meeting like this. Hello, Sir Philip. So happy to have you, love. Crazy old lady, I'm so happy you're here despite the cold medicine, but I hope it helps you. Hello, Ardo. Yeah, that's gonna be the judge tonight. Hello, Tammy. How you doing, sweet sis? Oh my gosh, you guys. Thanks for coming out. Hello, Rocky Lennon. And I was in the comments earlier today and I saw comments from Rosier Fam and I was just thinking about, all of the regulars and how much I miss you guys. Chex and Cherries and Linda Ebert and Dolphins and everybody. You guys, I love you. I really, really do. And when you're not here, I feel it. I feel it. I'm telling you. I love you guys all so much and I miss you. Every one of you. Hi, Pat Wood. Good to see you. Uh-oh. Okay. Well, I know exactly how to get her to do that. I know the moment this bag opens up, the dog appears. The nose is already going. It's she's a sniffing. Where is it? This bag wants to be complicated. There we go. Found it. Billy, you weren't the one that was supposed to appear. Hey, don't you dare. You quit it. She's supposed to come up from there. Come on, Ava. It's okay. Wait. Crazy old lady wants to say hi. Oh, you are hurting me. Oh, you sweet thing. Yeah, Billy, yeah, April rides the struggle bus nightly. It picks her up about 9:30 and it doesn't depart. Wait, you going right in for that, and you have been spoiled tonight. So you should be extra gentle with Mama because you've been super spoiled. Yes, you're a good girl. You're a good girl. Yeah, you taking your time with that one. That's some good cinnamon and pumpkin. Yeah, pumpkin. Yes, you're a pumpkin. Oh, you want one more? Should I give you one more pumpkin and cinnamon biscuit? One more. Whoa! She's like, I gave up for a second. I'm back. Hello, Nana Laura. How you doing? Oh, thank you. Yeah. He's a grumpy little butthead. Oh my gosh, I love him. But he is not impressed with Ava anymore. Like, he is over having Ava as a sister. He gives up. And now he's just like, he sees her and he's instantly sweat. I don't know what to do. I don't know what to do to get him back to being the loving creature that he never really was. He's always had that, little bit of an attitude problem. I love him though. He's my baby. He's still my favorite, absolute favorite cat. So before I can start, I received something today, and I can't put my leg up until I deal with that. I had to have it put there because it was too heavy for me to, continuously maneuver it. I asked the usual suspects, and they, mum's the word. Nobody answered. So I don't know who it's from yet. And I don't know what it is exactly. So yeah, it showed up. It showed up this morning, and I was kind of irritated because it's been raining all day, and the courier just put it right in the rain and left it right outside of my unlocked, open, closed front porch. Just pull the handle and put the box right there when it's raining. That's all I asked, really. If you're not gonna take it up the handicap ramp, at least get it out of the rain. They didn't. Luckily, it was only out there for a little while. The box wasn't completely saturated, but I do need to deal with it. I don't think it will be. I don't think it'll be Palmy. I have a suspicion that I think if I were to guess, based on how much it weighs, I'm gonna think that it's a box of wet cat food, the Friskies. I have that feeling, and that would not be Palmy. Now, a pallet of Ava treats would be Palmy. All right, let's see what this is. Whoever it's from, I am so appreciative. Okay, I gotta see who that's from. Oh my goodness, Bad Scooter. Thank you. I love these bags. Oh my God, that's heavy. Oh. Wow, that's heavy. I don't think anybody's going to wrap cat food. Oh. Okay, there we go. There we go. Oh my gosh. Okay, guys, this is hold on. Well, okay, so it's 16.31 pounds, whatever it is. I love this cuticle pusher. I talked it up last night, and I'm talking it up again tonight. It's my favorite cosmetic tool that is not used for cosmetics very often. You get them in like a 5-pack. Have them all over the house, and they're perfect for everything. Oh my gosh. Y'all. This is, oh my gosh. It's a Dutch oven, a cast iron Dutch oven. I wanted one of these so bad. I bought my mom one years ago. So the other day I was poking around the internet, and this short came up with this homemade bread. Y'all know how I feel about garlic bread to start with. But this homemade bread made in a Dutch oven with like 3 ingredients. And it's like 100 and some year old recipe. And it's no knead is what it is its big thing. And so you don't have to knead it. You put the yeast in the water, and you might have to put in a little bit of sugar, I think, because sugar is what the yeast feeds on. So then that's what causes it to activate, the warm water and a little bit of sugar, and then the flour. And then like it rises, you don't knead it. And when it's done, you just put it into a preheated Dutch oven and bake it. And it comes out as this rustic, artisan, crusty bread. And I'm like, oh, I have to have that, but I don't have a Dutch oven. So I threw it on my Amazon wish list. Oh my gosh. Thank you, Bad Scooter. I love it, and I'm so grateful. That is so cool. Yes. I am so happy. I love it. Yes, and it's cast iron. It's going to last forever. Oh my gosh. I remember seasoning those when I had them, when my mom loved cast iron. And so does my bestie. He cooks everything in cast iron. And so I've had to season them before. I have to set this on the floor. So y'all ignore my faces that I'm going to make for a second. Oh my gosh. Sorry, cats. That's for me. 4 ingredients. I wasn't counting. I was just thinking and rambling. But I don't remember if it said to use sugar. I just know sugar is very, very often used with yeast because that's what activates it. So the yeast feeds on it. And I don't think I've ever seen a yeast recipe that didn't have sugar. but I don't remember it being one of the ingredients in the actual recipe. So I might be wrong. I don't know. I'll have to go back and look now that I can actually make it. Absolutely. Yes, I will. I will put it in the Discord. Ooh, I got it. Hold on. Let's see. I can't see chat at the moment. Give me just a second. I am going to pull this up real super quick. All right, I'm not going with, I'm just going to go with one of the shorts. This is what made me want it.
This is the only bread recipe you'll ever need. It's one of New York Times' most popular recipes, and it comes from a baker named Jim Leahy. He created this method so that everyone at home can bake fresh bread. This is way better bread than you can buy in the store, and you don't even have to knead this at all. I'll put the recipe down below for everyone. This is the only bread recipe you'll ever need. It's one of New York Times' most
Yeah, isn't that amazing? It could be. I mean, I'm sure you can tweak it a little. I would not tweak it much. But didn't that look amazing? That's so good. And that crunch when they cut into it, like every single video that I watched, because I'm like, no, this can't be real. And so I kept looking at videos, and the number one thing that everybody showed was the crunch when you cut into it, and that crispy crust outside because of being in the Dutch oven. I'm just, oh man, I can't wait. I cannot wait. Oh, I've seen the enameled cast irons, where they have them in multiple colors and stuff. And those were options too. But I'm not picky, man. I love it. I love it. I'm so happy. And black goes with everything. I mean, heck. It's my favorite color. Or, my favorite absence of color. It's so good. It's so useful, and you can take it and you can use it camping on the fire. You can use it in the oven. You can use it on the stove. Oh my gosh. Like, it's so versatile. It's amazing. Talking about the bread. Oh, yes. Yes. I think I need that moment. Yeah. Hello, sweetie. You're too funny. You are too funny, Stephanie. I know. I love garlic bread. Oh my gosh. I made my usual garlic butter, but I made it a little heavier on the garlic. I think I went a little too heavy. I might have to now add a little bit of butter to take it back a notch. Because it's potent. Like, you can't even tell there's butter involved. It's like I spread pure pureed garlic on the toast and baked it. strong stuff. It's good. but it's good. You know, that can be taken a whole nother way. Oh. I know. Well, and okay, so you remember that chopper that I had that literally broke when I was using it when I was, doing videos and I was chopping garlic. It broke. The whole like where it connects at the top came out, and I tried for the life of me to put it back together, but that thing was from like the 60s. It was done. It done had its day. So I was like, okay, I had another one that was like off-brand Pampered Chef style. It had the zigzag for the blades. And every time you went down, when you came back up, it rotated just slightly, I was so excited about it because it was like, 10 pumps, and I am not going to finish that sentence because that would be clipped. Yeah, it was just, I could get garlic chopped super, super, super quick, and I was so happy. I used it once, and the where the lid connected to the metal post cracked. So the next time I went to use it, the knob on the top just flew off. It lasted once. One made in the 60s lasted until 2024. Sorry, a little behind here. And a modern one lasted one use. I guess I smacked that like button a little too hard. I was used to hitting that like button so hard, and that transferred over into my smacking the garlic knob and broke it. I don't know my own strength. Oh, what you do is you peel all of the garlic, all of it. You put it onto a sheet of aluminum foil, drizzle with a little bit of olive oil, salt it, and then you fold it into a pouch, or, just close it up real nice and tight. And then you put it into your oven at, I think, 375. I believe, you'll have to look it up, but I think it's 375 for, I'm not kidding you, like 4 hours. Like when you look up roasted garlic in the oven, it tells you like 2 hours or whatever. No. Keep it in there. Trust me. It will be this soft caramelized brown little garlic toes that are sweet. And when you use them in a recipe, like if it says to use 2 toes of garlic, use 4. Use more than what the recipe calls for. It's not as strong once it's roasted, but the flavor is so good. It's so much better. It's so creamy. Yeah, it's good stuff. Your whole house will smell like garlic. The whole thing. But it's worth it. And then if you have a vacuum sealer, you can actually like make it into little sections and freeze it, and then just use it whenever needed. It's so good. What are you, Earl? Earl, I know that's you. Just because you got down on the floor instead of being up on that furnace. I know you are the one back there. You little turd. Stop it. You don't need anything in my closet. You see the closet door opening by itself. I don't have Ghost. I have Earl. Who on earth? I am sorry. Give me just 1 second here. Whoever it is, I love you. But, oh. Hi, Palmy. I will read them in a minute. I love you. I'm sure if I look right now, one of those messages says, tell everybody in chat I said hi and I miss them. I'm sure of it. He's in his home, like far, 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 far away from me, sadly. He works a lot, and usually he's asleep by now, so I don't know what he's doing up. Probably working. Yes. Hello, Palmyra Productions, and we all miss you, and we love you. I know. One of these years, I'm serious, one of these years, we're going to have a big old get-together. Big old bash. Oh, he's going to like you. I'm not kidding. He said Tic Tacs, Jello and Tic Tacs when we were on the phone together. And then he gets in chat and says thumbtacks. And I'm like, where did the pokey come from? No. It was Tic Tacs. And I knew it was because I responded sprinkles. Aw. He can be. No, he is. And he's a sweetheart. He doesn't want anybody to think he's a sweetheart, but he's a sweetheart. I love him. Just tell your boss that you're how can we swing this? Let's see here. You're having a conference, and you mentioned work, so it's now work related. Well, you're one up on me because I'm not wrestling in Jello at all. So you've got me beat already. I forfeit. I will watch, though. I'll put good money on the fight. Okay. She could always join in. Tell her it's a recruitment opportunity. Oh, my tummy hurts. My tummy hurts. And Earl got that dang door open. Look at that. Once he got it open, he just walked off. He doesn't care to go into it. He just opened it. That's it. He just wants it open. He doesn't want any closed spaces in the house. Goofy little thing. I love him. Jello shots. Forget the hand sanitizer. Jello shots. Just a giant bath pool filled with Jello. And I don't know, can I say that without getting instantly demonetized? Is it past 15 minutes? Oh wow. It's 31 minutes. Yeah, Jello and vodka. Yeah. The other ones couldn't care. They don't give a hoot. Earl, on the other hand, he'll sit at that door and mess with it. He will just mess with it and drive me crazy because, you'll just hear him pawing at it and scratching at it until he gets it open. But the other ones don't care. Him, he does not want a door closed. You are as solidified to this deal as the Jello. Because nothing's on paper yet. It's still a deal in progress other than you've committed. See, look, the door is open and now he's fine. Now he's just like, okay, now I can chill. Goofy thing. Goofy kitty cat. I love him. He's such a good baby boy. Such a good baby boy. Right, Earl? Right, Earl? You're a good baby. Oh my goodness. Okay, so for the clip tonight, guys, I did so it's Judge Springstead. Hold on, there's one little tiny cat hair. There we go. It was stuck to my laptop. I don't know why the one cat hair bothers me, but the 50,000 of them on my desk are like just there. So it's Judge Springstead, and he his courtroom is notorious for not great audio. So I've gone through and I've enhanced the defendant's like where it seems like it's important special words, so I've gone through and I've enhanced it as much as I can. I might have missed a few spots because some of it I did a little blindly because the stream needed to come up, but I dozed off while editing, and so foreshadowing. I don't know what the third case is. No. But yeah, and that's why there was no thumbnail. I was too tired. I did not have time to make a thumbnail. I had time to take a nap. But I did really like the case. So
this is Donovan Harvey from San. He's got 4 files going here: 2313329, 2313331, 2313333, 2313334. He's represented by Mr. Greer, and all those files were set for a pretrial conference today. The court's been advised that these cases have been resolved. Is that your understanding, Mr. Greer?
It is.
Is that what you want to do, Mr. Van Zandt?
Sure.
Would you raise your right hand, please? You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, and Ms. Robinson, would you put the agreement on the record, please?
Yes, Your Honor. Agreement is that in case number 23-13329, the defendant will enter a plea to possession of methamphetamine and CCW. The people will dismiss the balance. People score the guidelines on that plea at 0 to 17. And there would be an agreement for a negotiated 20 months on each count, regardless of the guidelines. And all time would be concurrent with any time in 23-13331 and in 23-13331, the defendant will enter a plea to child abuse 3rd degree and domestic violence. The people will dismiss the assault with a dangerous weapon and child abuse 2nd degree. People score the guidelines on that plea at 0 to 17. And would recommend sentence within guidelines on the child abuse 3rd degree, 93 days negotiated jail on the domestic violence. In exchange for those, people would dismiss 23-13333 and 23-13334. The defendant must enter a plea to the entire offer to gain the benefit of each individual part. And if the defendant does decide to do that, I do have amended information, Your Honor.
All right, Mr. Greer, is that your understanding of the agreement?
Your Honor, he is on file number 23-13331. The prosecutor is dismissing the child abuse 2nd for a plea to child abuse 3rd. Did I hear that correctly?
Yes.
Okay, thank you, Your Honor. That's my understanding of the agreement.
And Mr. Van Zandt, is that your understanding of the plea agreement that resolves these cases?
Yes, Your Honor.
All right, so in 231-3329, leading to count 1, possession of methamphetamine, which alleges on or about May 16, 2023, which are in the city of Fremont, Wayne County, state of Michigan, that you knowingly or intentionally possess methamphetamine. This is a felony which carries up to 10 years in prison and or $15,000 fine plus costs. You understand count 1 and the maximum penalty? And you're pleading to count 2, carrying concealed weapon, same date, same location, that you do carry a dangerous weapon to a pistol, whether concealed or otherwise, in the vehicle operated or occupied by you. It was a Chevy Silverado. This is a felony which carries up to 5 years in prison and or $2,500 fine plus cost and mandatory forfeiture of the weapon or device. Understand count 2 in the maximum penalty.
Sure.
You're just missing count 3, felony firearm, which would have been 2 years in prison consecutive and preceding any other sentence that you've received. Do you understand that?
Yes, Your Honor.
You're just missing no insurance, driving license suspended, and operating a registered vehicle. Is that your understanding of how the charges are being resolved? All right. Now, in terms of sentencing, you have an agreement which for a specific cast in stone sentence, and that would be 20 months in prison to 10 years for possession of methamphetamine, and 20 months in prison to 5 years for the carrying concealed weapon. You understand that?
Sure.
These 2 sentences would run at the same time. You understand that? Just speak out loud.
Yes, Your Honor.
All right, thank you. And the advisory guidelines in this case would suggest a sentence between 0 and 17 months. So this is a slight upward departure from the advisory guidelines. Do you understand that?
Yes, Your Honor.
And apparently you're agreeing to a slight upward departure in exchange for a global resolution of all these cases, not the least of which would be the dismissing of the felony firearm, which would have been automatic 2 years in prison consecutive. Do you understand that?
Yes, Your Honor.
Now, in the Do you have the amended information?
Yes, Mayor Pro Tem,
Yes.
Yep.
and a copy has been
Yes.
provided to Mr. Greer as well.
All right, so in case number 231331, pleading guilty or no contest to count 3, domestic assault, which alleges that on a date range, July of 2023 to September 2023, that you're in the Bridgeton Township, Wayne County, State of Michigan, that you make an assault or assault and battery on Holly Galley, a resident or former resident of your household. This is a misdemeanor which carries up to 93 days in jail and or a $500 fine plus costs. You understand count 3 and maximum time.
Yes, Your Honor.
And they're adding this count 4, child abuse, 3rd degree, same date, time, allegation, same location, that you did knowingly or intentionally cause physical harm to a child. This is a felony which carries up to 2 years in prison or for probation up to 5 years. Understand count 4 and the maximum penalty.
Yes, Your Honor.
In that case, the domestic assault, and the most that you could get with that would be 93 days in jail. The sentence for count 4 would just be consistent with the advisory guidelines. Do you understand that?
Yes, Your Honor.
The prosecutor scored those at 0 to 17 months. So in that case, if I wanted to give you the absolute maximum penalty, assuming that it fell into the guidelines, the most I could do there would be 16 months. Do you understand that?
Yes, Your Honor.
And that this would run concurrent with the other file. You understand that?
Yes, Your Honor.
All right. Is that your complete understanding of the agreements to resolve these 2 files and the 2 that they were dismissed?
Yes, Your Honor.
Have you had sufficient time to consult with Mr. Greer about your charges in all these files, the plea agreement to resolve them, and the right to challenge any one or all of these cases at a trial?
Yes, Your Honor.
All right. The subject to the plea agreement in these cases, how do you wish to plead?
No contest.
Reason for no contest, please, Mr. Greer?
Civil liability and lack of memory, Your Honor.
Mr. Robinson?
No objection to that, Your Honor.
All right, the court does find that that's a sufficient reason for offering no contest plea to resolve these cases. Now, Mr. Van Zant, you understand with the no contest plea, you're not admitting these charges, but you're no longer denying them.
Yes, Your Honor.
Your attorney in advance of this hearing provided the court with, yes, it was police report and also preliminary examination transcript. The court's going to review that to determine if there's a sufficient factual basis for each of these offenses. Do you understand that?
Yes, Your Honor.
Do you understand that these that if I find that there's a sufficient factual basis to support these pleas, that I would find you guilty, you'd be convicted of these offenses, and it'd be on your record. You understand that?
Yes, Your Honor.
And you'd be subject to sentencing according to the plea agreements in this case. Do you understand that?
Yes, Your Honor.
You also understand that by entering this no contest plea, that you'd be giving up your right to have a trial of any kind.
Yes, Your Honor.
You also understand that you'd be giving up certain constitutional rights and other rights you would have if you went to a trial.
Yes, Your Honor.
We've listed those rights for you on a written advice and right sheet. It looks like you signed those back on February 12th. Did you read those documents?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
Did you go over them with Mr. Greer?
Yes, Your Honor.
Has anyone threatened you to get you to make these pleas?
No.
Has anyone promised you an outcome different than what was stated on the record?
No, Your Honor.
You entered these pleas of your own free will?
Yes, Your Honor.
Do you understand that if I accept your no contest pleas, you're giving up the right to later claim that these pleas were not your choice, or that they were the result of any promises, threats, or inducements which are not disclosed to me today?
Yes, Your Honor.
Do you understand that I'm not bound by these plea agreements, but if I don't go along with them, you can withdraw your.
Yes, Your Honor.
You now give up your right to have a trial of any kind, and all the constitutional rights and other rights you would have as a result of that trial, and do you affirm your no contest pleas?
Yes, Your Honor.
And Ms. Robinson, any objection if the court reviews the information that was provided by defense?
No objection, Your Honor.
The court has had an opportunity to do that, and I do find that the elements of all these offenses are contained therein. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
No, Your Honor.
Is the defendant competent to enter these pleas?
Yes, Your Honor.
Yes, Your Honor.
Is the court compelled with MCR 6.302?
Court has, Your Honor.
Yes, Your Honor.
All right, the court does accept the plea that you find to be knowing, understanding, voluntary, and accurate. I'm going to refer the defendant to the probation department for preparation of pre-sentence investigation report. I'll set sentencing for 240 on April 8th. That's all for today.
Thank you, Your Honor.
Okay, guys. Real quick update. Stephanie, you made his hit list. Good job. So I checked all of the texts from Palmy. And he's kind of grumpy because he's been up since 4 a.m. and he was just repeat texting because he heard my phone wasn't muted and he wanted everybody to know that he was around. He can't chat though because I guess Rumble is set on fire tonight with the issue with P. Diddy, so he's working hard. It's on like Donkey Kong. Oh, Nana Laura, really? It used to be highlighted in orange. Everybody's talking about the new update now made it so that you don't see when you at someone's name. I noticed it was highlighted gray, but I didn't even think anything of it. But yeah, it used to be highlighted orange. You're right. Huh. They did that just a few days ago. They did this major update. He's scared of us. Yes, it's a chat full of ladies tonight for the most part. There's gotta be guys in there. I know I saw Ardo. Ardo's a guy. Other than that, it's a room full of women and we're talking about eating our way out of a pool of Jello shots. I'd be scared too. Oh, Sir Philip is here. Yep, Sir Philip is here. So we've got a couple of guys in the chat. You don't have to be scared. We got Shane. That's 3 on your side. Oh my gosh. But yeah, I just had to update you guys. Can try what? Oh, you changed your name? Oh, let me see. Okay. Hold on 1 second. At Tammy 13. Okay. Was it highlighted in chat? Did it work? Sorry, Al, for the segue from the court docket. Gotta solve tech problems. Need to call Earl. He has to teach us how to Zoom. Tech kitty. Well, darn it. What am I doing wrong with it then? I don't know. It is a special Jello. Well, I know on I know on a laptop, if you start typing someone's name, it won't work for me because I'm on StreamYard, so I've got a third-party interception in the middle there. But if you're on YouTube chat on a laptop and you start typing someone's name with an @ it'll populate, and then you can select it. You can't do that on a phone, but I wonder. I just waiting for the right time. All right, well, we'll figure it out. Crazy old lady was able to solve her membership issue. If we can fix that, we can fix anything. Okay, guys, I'm gonna go back to the case. The next one is the main one for the night of oof.
You're set.
Elizabeth Troutline. This is case number 2413376 FH. People versus Elizabeth Candace Troutline. This case is set for a pretrial conference. And is this going to be a plea today, Mr. Greer?
It is, Your Honor.
Is that correct, Ms. Troutline? All right, Ms. Troutline, before we get started with some of the details here, you were placed on bond in this case. That bond that would prohibit you from using alcohol, marijuana, and other illegal controlled substances. And people that have been charged with possession of methamphetamine, almost all of them continue to use methamphetamine when they're on bond. So have you been abiding by the terms and conditions of your bond?
I'm confident I can pass the drug test.
That's not what I asked you.
I have not broken.
All right. So we'll continue on. I'm going to order that you get a drug test. And if you pass that test, we got no problems. If you test positive for a controlled substance, you got problems. Right? What do you think you're going to do? All right. And Ms. Robinson, would you put the plea agreement on the record, please?
Yes, Your Honor. The offer is that the defendant will plead to counts 1, 2, and 3. The people will dismiss the double drug notice as well as dismissing counts 4 and 5. The people score the guidelines on the CCW charge at 0 to 9 months and 0 to 11 months on the methamphetamine charge. Would offer a cap at 6 months.
All right, and Mr. Greer, is that your understanding of the plea agreement in this
It
case?
is, Your Honor.
Is that the agreement that you've made, Ms. Troutline? All right, the charges that I swear you in already? Have you raised your right hand already? All right, would you raise your right hand, please? You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. So the charges that you're entering a guilty plea to read as follows: that on or about December 17, 2023, that you were in Dayton Township, Wayne County, state of Michigan. Count 1, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by you. This was a Mitsubishi Outlander. This is a felony which carries up to 5 years in prison or a $2,000 fine plus cost, mandatory forfeiture of the weapon or device. Do you understand count 1, the maximum penalty? Count 2, same date, same location. That would be that you did knowingly or intentionally possess a controlled substance, methamphetamine. This is a felony which carries up to 10 years in prison and or $15,000 fine plus cost. Do you understand count 2 in the maximum penalty? We're dismissing the double drug enhancement. Looks like you had a fairly recent drug conviction. What was that for? What controlled substance was that? All right. Count 3, same date, same location. This is operating with the presence of a controlled substance, that you did operate a motor vehicle on South Rich Avenue when you had methamphetamine in your body. This is a misdemeanor which carries up to 93 days in jail and or $100 to $500 fine plus cost and or 360 hours of community service. You can order rehabilitative programs. Vehicle immunization is mandatory with prior conviction.
Just wait.
Understand count 3 in the maximum count. We're dismissing a 90-day misdemeanor, operating an unregistered vehicle at 1 year, no insurance. Do you understand that? All right. Now, you have a sentencing agreement that should be sentenced consistent with the advisory guidelines, and they range from 0 to 9 and 0 to 11 months. As long as 6 months falls within the range of guidelines, as I scored them at the time of sentencing, you have an agreement that the upfront jail time would not exceed 6 months. Do you understand that? You would also be consenting to a term of probation. You understand that? Is that your complete understanding of the plea agreement in this case? Have you had sufficient time to consult with Mr. Greer about your charges and this plea agreement?
I have.
Subject to the plea agreement, how do you wish to plead? Understand that if I accept your guilty plea, that you'd be given up the right to have a trial of any kind.
I do.
You also understand that you're giving up certain constitutional rights and other rights you would have if you went to a trial. We've listed those rights for you on a written advisory right sheet that you signed today. Did you read that document? Did you understand those rights? Has anyone threatened you to get you to make this plea? Has anyone promised you an outcome different than what was placed on the record?
No.
You entered this plea of your own free will? You understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice, or that it was a result of any promises, threats, or inducements which are not disclosed to me today. You understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea. You now give up your right to have a trial of any kind and all the constitutional rights and other rights you would have at that trial, and you affirm your guilty plea. Are you pleading guilty because you are guilty, or is there some other reason why you'd be offering these guilty pleas today?
I am pleading guilty because I am guilty.
Is it true then that back on December 17, 2023, that you were in Dayton Township, White County, state of Michigan?
Yes.
Looks like you were operating a motor vehicle on South Rich Avenue, is that correct?
Yes.
And were you stopped by the police?
I was actually parked
Oh,
on the side of the road with my hazards on. I guess there was a complaint that was made. And they pulled it behind me, and that's how I had that interaction, I guess.
okay. Were you alone in the vehicle? Were you alone in the vehicle? Whose vehicle was it?
It was a friend of mine.
How long did you have the vehicle?
I did not have the vehicle. I was left with the vehicle.
Oh, okay. So you didn't drive it to that location? You were just sitting?
I was waiting for my ride to pick me up because we were having issues. I don't know what the issues were exactly. I'm not a mechanic, but there were issues with something underneath the car had made like a loud clanking noise and was steering really hard to the left or to the right. The person that I was with ended up getting a ride that came sooner than mine. Mine got lost. I didn't have service on my phone to be able to direct them where I was. I had several people ask me if I was okay, if I need help. As a female in the middle of the night, I don't typically like accepting help from strangers, let alone men. So I just kept saying no. And one of those people ended up calling the police saying that I must have been slurring my words or something. And
You sitting in the driver's seat?
I was.
Is the vehicle running?
No, the hazards were on though.
Okay, so supposedly someone else was driving, and then they heard a clinky clanky noise under the vehicle, as she says, and that person that was driving pulled over, and someone came and picked that person up and left her alone at the vehicle. And she ended up in the driver's seat with the hazards on and the car parked, but she was never driving.
Did you have the keys to the vehicle?
I had the key fob, but not the key.
Vehicle was off. Is that right?
Yes.
we had to keep Bob on you, but you never drove it. Just sitting. All right. Now, when the police come up to check on you, did they find a pistol?
They found a pistol after I had been put in their cruiser, yes.
All right. Where was the pistol located?
In the front passenger seat and backpack.
All right. And whose backpack was it?
Um,
And what kind of gun was it?
5.9.
Okay.
Yeah, I love her court attire.
Did you have a concealed pistol license? Was the pistol loaded?
Not to my knowledge, it shouldn't have been. I don't think so.
All right. Did they find some methamphetamine?
Like on paraphernalia, there was probably enough in there that they were able to hold this charge.
So when you say paraphernalia, was there a pipe or a baggie?
Yeah, yeah, there was a, it was actually a water bomb. But there was paraphernalia in that and another pipe.
Okay. And it sounds like they tested the pipes and they tested positive for methamphetamine.
Yes.
Are these pipes in your backpack as well?
One of them was, I believe, one of them was in the center console.
All right. Was the one that was in your backpack yours? And did you previously use that to ingest methamphetamine? All right. So, Ms. Robinson, Mr. Greer, anything more to the story with operating this motor vehicle? It's been a while since I've been out of the OWI game, but a non-running vehicle, said she didn't drive it there, she was sitting there. Is that considered operating?
Well, the law, as I understand it, is that she had the key fob, which I think also starts the vehicle. There had been an accident. She indicated it was on the side of the road, but there, she apparently admitted driving into the ditch.
An accident? Well, that didn't come up in that whole roundabout. I wasn't driving, but I was in the driver's seat, and the person left, and it was just parked, hazards on. What kind of accident there, sir?
There was nobody else around, and so what the law assumes is that, it's my understanding, what the law assumes is that she had to get there somehow, so she drove.
You're indicating that she made some statement to the police indicating that she drove the vehicle to the vehicle?
Yeah, it said, if I may, Elizabeth stated, it crashed because I moved it there out of the road. I drove into the ditch on purpose. She didn't realize, she was trying to pull off the road, didn't realize that it turned into a ditch and went into the ditch. I don't think it wasn't a major accident or anything, but she was in the ditch, according to what this police report says, her statement.
You made that statement to the police?
Yes. Are you asking me or?
Asking her.
Oh, I'm sorry.
Did you make that statement to the police?
I did, but it was kind of taken, I did say that, but that was after I had been kind of picked at a little bit, and I was a little frustrated. And I was just trying to get to the point of like being done with that conversation.
You lied to the police then? When you
So I
told them
had
that
told
you-
them several times prior to that, that I was not the one driving.
Maybe we're splitting hairs here. So, or what is what you're telling me, or that someone else was operating the motor vehicle and then it had this clunky noise or whatever. So that individual decided to pull the motor vehicle over to the side of the road. Do I have it so far?
Yes.
Okay. And then that somebody came and picked up that other person and you were left there, is that right?
Right.
And then did you operate the vehicle for a short period, a short distance to get it further off the road and accidentally went too far into the ditch?
Yes.
I want you to tell me the truth. If it didn't happen, it didn't happen. But I'm just trying to understand how you would tell the police one thing and now you're telling me something different.
I'm very nervous right now. Just because I've never been in circuit court, so sorry. I was frustrated when I started saying that I had drove. When I said I meant us as a whole, the car as a whole, we moved it. Anytime that I had said we or the person that I was with, they kept telling me, sorry, that my story didn't make sense and it wasn't adding up.
There's a reason they kept telling you that.
And I was getting really frustrated because I've repeated myself several times at this point, just to be told my story doesn't make any sense. So out of frustration, I had said, I moved it here on purpose. Because they were trying to say that it was a like accident, or that because I was intoxicated, I went off the road. And that's not what happened.
So you're telling me today, under oath, that you never operated, moved that vehicle in any fashion?
Correct.
So Ms. Robinson can't accept the plea as to count 3. You want to go forward with the other 2 counts, or we throwing the baby out with the bathwater?
Your Honor, I would agree that what was said today does not allow the court to take a plea, but unfortunately, this is a package deal.
The court is not going to accept the plea. How long is this trial going to take?
I don't believe it should take more than the normally assigned 3 days, Your Honor.
Okay, Mr. Bear, what do you think?
Your Honor, I would agree with that.
All right, we'll set this case for trial by jury, June 4th, 5th, 6th, and 7th. Now we'll set this case for the final conference on April 8th at 2:50.
What time, Your Honor?
2:50 for the
Thank you.
final conference. Now, the court is going to order that Ms. Troutwine go to Accurate Screen immediately to get a drug test. If you don't go there immediately, the court's going to revoke your bond. If you go there and test positive for controlled substances, the court's going to revoke your bond. If you try and use somebody else's urine or something like that, the court's going to revoke your bond. If you go there right away, take the test with your own urine, and you pass, you're free to go on home. If you don't do all of those things, come on back to court.
Your Honor, she had a warrant for not paying a booking fee of $280 that she paid today, so she may need the court to pay for the test and then she'll reimburse at a later date.
Okay, we can advance the cost of that test. It's $30. We'll advance the cost, and if you either plead guilty or found guilty, we'll recoup that advance cost. All right.
Thank you, Your Honor.
So
Let's go ahead and ignore it.
I have a real strong feeling you're not going to pass.
Yeah, I'm gonna pass.
Okay, why are you crying?
Because I felt like I was talking out of turn and I'm really nervous. I've been trying really hard to stay sober and it's not been easy for me. And I just have a lot of other stuff going on too on top of this. I've been working with CMH. She was going to recommend 3 months of rehab.
Your Honor, I can say this. I dealt,
That's okay. You did fine today. I'm not mad at you for not entering a plea to that other case. There's no problem, because you did exactly what I told you. I wanted you just to tell the truth. You told the truth, and there's no problem.
we'll take care of that, Your
But
Honor.
from the prosecutor's perspective, they tried to resolve all of these things, and one had to go with the other. So that's why we set you for the trial. Okay? So go take your test. If you don't pass it, come right on back and we'll talk about it. Okay? All right.
Thank you, Your Honor.
Next up is Tara Lee Moore. Case number 231323. Moore is not here yet again. Court received information from your office, Mr. Greer, that apparently she's still in the hospital. Now, were you aware of that, sir?
No. I've been trying to reach her for the last 6 days. If the court received that information today, you received it?
Yeah, Marcy from your office called and said that Tara called her and said that she was still in the hospital.
Yeah, I'm speechless.
The court's gonna do the same thing I've been doing every single time before. The court's going to issue a warrant for her arrest for failure to appear. Mr. Bureau will give you 48 hours to provide verification from her that she's still hospitalized.
Thank you, Your Honor. Same bond, that be the 25,000
Yeah, she's
cash or surety.
she's never posted a bond yet, so
Very well. Thank you, Your Honor.
let's get to that eventually. All right, so this is case number 231325 FH, People versus Bryce Jacob Felsus. Received notice that the defendant wanted to enter a contest plea. I written down in my file, no deals, and I wrote that down September 26th of 2022. It's like on the same day they ordered a drug test. Just positive for cocaine, opioids, oxycontin, and THC. Probably told me he hadn't used anything, so it's probably why I said no deals. Any of that ring any bells, Mr. Greer?
I talked to Mr. Stay, and he said he would, if the court would allow it, he would offer that same plea again.
Mr. Felix have a trial date pending here?
No,
Date pending? Looks like we had a trial set for the end of November. Ms. Fritzman, do we know what happened there?
My notes indicate that the warrant was active at that time.
Okay. So we had a pre-trial conference. Then he failed the drug test. The court issued a bench warrant for his arrest, and we kind of never heard from him again. Does that sound about right? All right. So Ms. Robinson, what plea are you offering?
Your Honor, as Mr. Greer indicated, he did reach out to Mr. Stay, who said that the court had said no late agreements, but in the thought of getting it done, if the court would allow it, the people would offer again that the defendant would plead to count 2 and 3 with a habitual offender, third offense notice with the negotiated 12 months. However, again, the people are aware that the court did previously say no late offers and that we were prepared to go previously. So if the court is not inclined to take that, to allow a plea to that, people would be prepared to head to trial at this time.
So Mr. Felix, we got the note from you that you were over in the Costa County Jail. Why were you over in the Costa County Jail?
Over there right now on resisting an arrest and felonious assault, Your Honor.
Okay, and those charges are pending over there?
Yes, Your Honor.
Okay, you've got an attorney?
Yes.
All right. And what stage of the proceedings are you over there? Have you got a deal locked down or heading for trial or what?
I'm looking at a R&O plea, keeping it in the county. And they're talking about running a concurrent if this plea goes through, Your Honor.
Mr. Niegos, Your Honor, is his attorney in Big Rapids. In Costa. It's set for trial.
That'll be after, that'd be in May, correct? I have a plea deal coming up here March 12th.
Resume June. Oh, I see, okay.
I'm all right with this deal. I mean, basically, the
I see.
We do have habitual offender attached to this. Habitual offender court, which is obviously not good, but we're talking about 2-year resistant obstructing the 1-year misdemeanor. So I'm all right with the negotiating here.
Thank you, Your Honor.
All right. Is that your understanding of the agreement, Mr. Mayor?
It is.
Is that your understanding as well, Mr. Felus?
Yes, Your Honor.
Raise your right hand, please. Do you solemnly swear oath or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. So the charges that you're entering a no contest plea to read as follows. That on or about June 4, 2023, that you were in Goodwell Township, Donovan County, State of Michigan. Count 2, resisting obstructing police officer, that you did assault, battery, or wound, resist, obstruct, oppose, or endanger Chuck Myers, the deputy sheriff of the county of Nuevo, that you knew or had reason to know was lawfully performing his duties. This is a felony which carries up to 2 years in prison and or $2,000 fine plus cost. A consecutive sentence may be imposed if the assault was committed in a place of confinement, or for another violation arising out of the same transaction. Understand count 2 is the maximum penalty.
Yes, Your Honor.
Count 3, operating while intoxicated, second offense, same date, same location, that you did operate a motor vehicle on the highway, Pine Avenue, while under the influence of alcoholic liquor or having a bodily alcohol content of 0.08 grams or more for 100 milliliters of blood. They've charged us as a second offense, believing that you were previously convicted of operating while intoxicated January 18, 2022 in the 78th District Court for Nuevo County. Do you have that prior conviction, sir?
Yes, Your Honor.
Therefore, upon conviction, you are subject to enhanced sentence, which would include fines of 200 to 1,000, minimum of 5 days in jail to a maximum of 1 year, 30 to 90 days community service, rehabilitative programs, cost of prosecution, reimbursement to the government for emergency response, vehicle immobilization is mandatory of not less than 90 days and more than 180 days. You understand count 2 and the maximum penalty.
Yes, Your Honor.
This, I'm sorry, that was count 3 that I just read, sorry. And count 2 is, has the potential of being enhanced by habitual offender third. What that means is that you have at least 2 prior felony convictions or attempts to commit felonies. What it looks like here is that you were convicted March 5th, 2018, false report of a felony in the 49th Circuit Court from Acosta County. Do you have that prior conviction, sir?
Yes, Your Honor.
And October 12th, 2020, possession of methamphetamine or ecstasy, again in the 49th Circuit Court from Acosta County. Do you have that prior felony conviction as well?
Yes, Your Honor.
Therefore, you may be looking at enhanced penalties. The maximum penalty could go from 2 years to 4 years, and the maximum fine could go from 2,000 to 4,000. You understand how the habitual offender third could increase your maximum penalties.
Yes, Your Honor.
You have a plea agreement in this case that you served 1 year in the county jail. You understand that?
Yes, Your Honor.
Now, that's no negotiations, no chiseling, just doing it. You understand that?
Yes, Your Honor.
You would also be consenting to a term of probation. You understand that?
Yes, Your Honor.
Is that your complete understanding of the plea agreement in this case?
Yes, sir.
We had sufficient time to consult with Mr. Greer about your charges and this plea agreement.
I did.
Subject to the plea agreement, how do you wish to plead?
See no contest.
And Mr. Greer, the reason for the contest?
Your Honor, civil liability and lack of memory.
Ms. Robinson?
No objection to that, Your Honor.
All right. So, Mr. Felus, do you understand with the no contest plea? And I do find that that's a sufficient reason for offering no contest plea. With a no contest plea, you're not admitting this charge, but you're no longer denying it. Do you understand that?
Yes, Your Honor.
The court's been previously provided a copy of the police report. And if I find that the elements of these offenses are contained therein, I would find you guilty. You'd be convicted of these offenses. It would be on your record, just as if you had pled guilty or you were found guilty at trial. Do you understand that?
I do.
You would also be subject to sentencing according to this plea agreement. Do you understand that?
I do.
You also understand that if I accept your no contest plea, that you are giving up the right to a trial of any kind.
Yes.
You also understand that you're giving up certain constitutional rights and other rights you would have if you went to trial.
I do.
You received and read a circuit court plea advice and rights form.
I read it to him when we did that.
Yeah,
Remember I read it to you?
yeah,
So, Mr. Felix, you've read that document or had it read to you, is that correct?
yes, Your Honor.
And did you understand those rights?
Yeah,
And you're signing that document today, sir?
yes, sir.
If you want to take a minute and refresh yourself on that document, that's okay too.
I think I understand, Your Honor.
Right. All right.
Thank you.
Mr. Felix, do you understand that you're giving up the right to have a trial of any kind, and all the rights that are on that document?
Yes, Your Honor.
Has anyone threatened you to get you to make this plea?
No, Your Honor.
Has anyone promised you an outcome different than what we've put on the record today?
No, Your Honor.
Are you entering this plea of your own free will? You understand that if I accept your no contest plea, you're giving up the right to later claim that this plea was not your choice, or that it was a result of any promises, threats, or inducements which are not disclosed to me today. You understand that I'm not bound by this plea agreement. If I don't go along with it, I will withdraw your plea.
Yes, Your Honor.
Do you now give up the right to have a trial of any kind, all the rights that you have at that trial, and do you affirm your no contest plea?
Yes.
Ms. Robinson, any objection to the court reviews the information provided by Mr. Greer?
No, Your Honor, no objection.
All right. The court has had an opportunity to read that to the court today, and I do find that the elements of both of these offenses are contained therein. The court's going to refer the defendant to the probation department for preparation of pre-sentence investigation report. We'll set sentencing in this case for April 8th at 3 o'clock.
Okay. Cool. That's a good idea. Yes, sir. I'll be in touch. Get on.
Oh, for everybody watching on replay crew, I'm sorry, we're having a lot of fun over in the chat. And Sir Philip has decided that he is now Marquise Philip, because he doesn't have to type it. I'm sorry, but she's not available at the moment. She's currently dog napping. She's like, I don't have time for shenanigans that don't involve treats. Oh, yeah. So we have the palette of lemon lime jello and itching powder ordered for Stephanie, courtesy of Palmy. And I don't know how he thinks that's going to go, because the whole deal with Emily is that he's jello wrestling her. So with thumbtacks. And now he's jello wrestling Stephanie with itching powder. So what I'm hearing out of this is every time he's punishing someone, he's punishing himself. But I think that's kind of the story of Palmy's life. Hi, C. Jenny. Welcome. And Stephanie suggested barbecue sauce, which I'm all for that one. I like mine tangy anyways. Sweet and tangy. That's me. I know. He's so mean to us. Oh. Sir Philip to Marquise Philip. And I think, isn't there a rule he can't change it now for like 20 some days or something like that? A Borat costume? Isn't that just a suit? Isn't I've never actually seen Borat, I'll be honest, but like I thought like the posters of it that I saw, it was just he was a guy and he had a suit and a mustache. Oh, twice in 14 days. Okay. Oh. Well, here I am spouting rules of other platforms. I'm right on something, just, never where I intend to be right. Oh, that wasn't the one I meant to click. The chat jumped. I meant to click that one. You really want to see Palmy in that? It's called a Speedo. No, we're good. We're good. We're good. I'm sure you don't have one of Palmy. If you do, send it. But if it's Borat, I'm good. I don't know. I don't wanna. Oh. Oh. That's no Speedo. That's a Speedo Leo. Oh, I thought you loved me. Oh my gosh. Oh my gosh. No, you don't love me? I'm hurt. Genuinely hurt that you made me look at that. Oh, I gotta pull it up on the actual computer though. Otherwise, I gotta hold my phone up to the screen. Hold on. Okay, guys. This is the one she sent me. Oh, that is a whole lot of I don't want to see. Yep. I've never seen it. Right? bit. Yeah, a bit. Yep. Yeah, Tammy said she wanted to see Palmy in a Borat swimming suit. And I didn't know what that was. And she just felt the need to show me. I've never seen the movie. I had no idea. I thought it was just a man in a suit. Okay. Well, we know Stephanie's type. Oh, in your lime green pool of jello. I love Mr. Bean. I am a true Mr. Bean fan. He's hilarious to me. Ditto. Other than for laughs. They are brave. Only by personality. No one has ever seen him. He's elusive. I've seen him. He's cute. Not even for laughs, Emily. Oh, my tummy hurts, you guys. You guys are amazing. My tummy hurts so much. Oh. And it's only 1:14. Good thing I got another docket. I gotta switch it over to the other drive, though. No! Undo that. Oh, what did I just do? I just moved a folder. What did I move and where did it go? How do I see what I just did? Hopefully I didn't do anything. Hopefully it didn't actually move. Because I'm not actually in the drive. I'm in the present. I don't know. Ugh. Tech Kitty. He's on his break. Well, where is it? Oh, I'm still in the Palmy Drive. There it is.
As I suspected. So let's go on the record in the matter of Pepper, file 240700SD, and appearance, please.
Thank you. Mike McEwen on behalf of Miss Pepper. She's sitting to my right. Say your name, please.
Danielle Pepper.
All right, Ms. Pepper, Mr. McEwen has reached a resolution with the prosecuting attorney whereby you are going to be allowed to make a plea to a lesser charge of operating while impaired. Is that your understanding?
Yes, Your Honor.
Okay. Now, you understand, ma'am, that you have a complete right to go to trial. And if you did go to trial, the prosecutor would be would be required to prove you guilty of each of the elements of the charges against you beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand further that if you make a plea here today, you're going to tell us you're guilty of that lesser charge. There's not going to be a trial of any kind. Is that your understanding, and is that your intention?
Yes.
Yes, Your
that is
Honor.
the intention, Your Honor.
Mr. Bjorklund, I am speaking to Ms. Pepper right now.
Oh, excuse me.
Ms. Pepper, has anyone tried to frighten you or force you into doing this?
No, Your Honor.
Has anyone made any promises to you that I am not aware of?
No, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
Are you on probation or parole right now for any other criminal convictions?
No, Your Honor.
Mr. McEwen, you want to ask your client the questions requisite of the plea itself?
I will, Your Honor. Thank you. Ms. Pepper, did you operate a motor vehicle in the county of Allegan, state of Michigan? And I'm going to pull up the date. I apologize. I have it right here in front of me on February 16th of this year.
Yes, Your Honor.
Before you operated that motor vehicle, by the way, was that in the county of Allegan,
Yes.
state of Michigan, if I didn't ask that?
Yes, it was, Your Honor.
Before you operated that motor vehicle, did you consume alcohol?
Yes.
As a result of that consumption of alcohol, was your ability to operate that motor vehicle impaired, at least to the degree it would have been observable by a reasonably observant individual?
Yes.
And did you take a blood or a breath test?
Yes.
And you recall what the results of that test were?
Yes, I would. It was a 0.24.
Thank you.
Are you satisfied with the basis that you provided, Mr. McEwen?
I am, Your Honor.
You have provided me with the basis to accept the plea. I will do so. Mr. McEwen, understanding this is a rather substantial step down from a 0.24 to an impaired. So, but go ahead, Mr. McEwen.
Thank you, Your Honor. Your Honor, I've had extensive contact with this young lady and her mother. I would like to put into context the events that kind of led to her arrest. She has never put herself in this position before. She's been undergoing treatment with Pine Rest for now about a year for various issues, some of which are detailed in the substance abuse assessment that I provided to the court for the court's review. At the time of this event, her medication had been modified. They were in the process of modifying it, so they were weaning her off one medication and getting ready to introduce another one. She had some adverse reaction. She was in a pretty unstable state at the time. She was feeling very despondent at the time, and she left her employment at a convenience store, and she consumed a very large amount of alcohol.
That sounds like the most intelligent move she could have chosen. I'm having negative effects to my medication. Let me drink. Would not have been my first choice of activities in that circumstance.
In her state of depression, she completely blacked out. She ended up hitting a mailbox. Really has very little recollection of the events that occurred throughout that process. They contacted her mother ultimately. She was ultimately arrested and consented to the blood draw, which revealed, not surprisingly, a very, very high blood alcohol level. What she drank was hard liquor, and she drank it in her vehicle right before she left to go home, and had an understandable reaction to it. Since that time, she's been working with her therapist and her med prescriber through Pine Rest. They have gotten her medications adjusted. They're stabilized now. She's in a much better place. She does treatment, I think, every other week with her therapist. She did meet with Judy at Pathways regarding the substance issue. She was very forthright with Judy about her situation. And the assessment reveals that she does not appear to have any kind of underlying alcohol issue or any dependency issue, other than, of course, a very serious incident of alcohol abuse. She has not consumed alcohol since then. She's committed to not consuming alcohol at all. This has been a very scary event for her. The day after, or a short time after this event, she was actually contacted by the arresting officer, who took it upon himself to reach out to her and to discuss with her kind of the danger of the situation she had put herself in, and put into context some of her behaviors on that evening. So it's very commendable. It's made a huge impression on this young lady that he took his time to do that. He gave her the address and the contact information for the individual whose mailbox that she hit. She reached out to that individual. They paid for the damage, apologized to those homeowners for what had occurred. I provided the court and the prosecutor's office with a receipt verifying that. She followed Judy's recommendation, Miss Hall's recommendation regarding treatment. She did the victim impact panel. She did the highway safety course. She works 2 jobs. She works at a convenience store. She also works at a greenhouse that's seasonal. She lives on a 4th generation family farm, a dairy farm. They have over 200 animals, between 80 and 90 are milking dairy cows at any time. So she helps in that endeavor. As I said, she still lives at home and for the foreseeable future plans to continue to do so. I don't think she's taken this matter lightly. I think it's been a very serious situation for her and her family. As I said, she's accompanied by a parent every time I meet with her. Her mother's in my office today. So we understand that this is not something to be taken lightly. She put herself in a very dangerous situation. But I think she's learned a great deal from this, Your Honor. Thank you.
Ms. Pepper.
The one thing I will say, compared to the girl in the previous docket who refused to take accountability for anything, at least this girl has had the sense to step up and take responsibility and to admit, hey, I screwed up. So I'll give her props for that. She made a very, very reckless, irresponsible choice that could have cost her her life or could have cost an innocent person their life. But at least she's had the sense to recognize that.
Anything further you'd like to state?
I am really sorry for having done this and potentially risking hurting anybody's life. This is not something I ever want to do again. And was a very big eye opener as to how much more help I needed to get and stuff like that. And having to apologize to people, especially when I could have hurt someone. So yeah, it was definitely not something I've ever experienced, and having to experience it was very traumatizing. And I just want to apologize to the officer for you guys having to come in, but I appreciate taking the time for seeing me. So thank you, Your Honor.
Well, it sounds like you have an appreciation for the safety that you've imperiled in regard to the public, but our concern is also for your own safety. And I'm glad to hear that you're getting the help you need to address these issues. It's a very significant blood alcohol content, so I am rather concerned. So I'm appreciative that Mr. McEwen took the time to explain the extensive basis for the rationale as to why the people would have agreed to this as well. It does appear that you're taking this seriously. It doesn't look like this is going to be an ongoing thing. But before you leave that office today, I want to have Mr. McEwen revisit with both yourself as well as some other who is also there, the ramifications and consequences of any future incidents of drinking and driving, because the ramifications become more significant, but also it is just a matter of, again, it places the public and yourself in danger, and we want to do everything we can to prevent that. That being said, I have reviewed the victim impact panel and have noted that I have reviewed the substance abuse assessment and note that you did complete the victim impact panel as well as the highway safety course identified. So I appreciate that. I will impose fines of $200, state costs of $50, court costs of $400, crime victim right fee of $75, for a total of $725. I'll give you 90 days to take care of that. If you need longer, just reach out to the court and we'll work with you. If you have any questions, ma'am, just follow up with Mr. McEwen. He'll assist you with that. Other than that, good luck to you.
Thank you, Your Honor.
Thank you, Your Honor.
You can leave the court. Good luck to you.
Thank you.
You're welcome. All right, let's go back down to Mr. Half here, so we don't keep him hanging around here all day. Mr. Half, what are we planning to do?
My client plans on accepting the offer from the people at this time and entering a guilty plea.
Right, Mr. Woolery, in regard to this matter, do we need to set this matter for sentencing, or are we going to be able to proceed to sentencing today? Or do we need victim notice?
We can proceed today, Judge. Thank you.
All right, let's go on the record in the matter of People State of Michigan versus Matthew Gessin, file 240356 SM. Let's have appearances.
Mark Woolery, on behalf of the people, Your Honor.
Sean Half for Matthew Gesink.
Mr. Gessin, state your name, please.
Matthew Gesink.
Okay, very good. Gesink, I apologize, I mispronounced that. No disrespect was intended. Mr. Half, want to state your understanding?
My understanding is that upon successful plea to domestic violence today, the people would have no objection to Mr. Gesink being sentenced under the diversion program.
Okay. Accurately stated, Mr. Woolery?
Yes, Judge.
Mr. Gesink, you heard what your attorney stated. Is that your understanding?
Yes, correct.
Mr. Gesink, you understand that you have a right to proceed to trial, and if you did proceed to trial, the prosecution would be obligated to prove you guilty beyond a reasonable doubt of each of the charges brought against you. Do you understand that?
Yes.
You understand further that if you make a plea here today, you're going to tell us you are in fact guilty of this matter. There will be no trial of any kind. Is that your understanding, and is that your intention?
Yes.
Has anyone tried to frighten you or force you into doing this, sir?
No.
Has anyone made any promises to you that I am not aware of?
No.
Are you currently on probation or currently on parole for any other criminal convictions?
No.
Mr. Half, you want to articulate a basis for the underlying charge?
Yes, Your Honor. Matthew, on or about January 27th, 2024, were you at 4579 East Shore Drive in Layton Township?
Yes.
And is that in Allegan County, Michigan?
Yes.
Okay, what is your relationship to Sarah Gesink?
She's my wife.
She's a wife, and you have kids with her, is that correct?
Yes, one.
Okay. And on or about that date that we just mentioned, did you get into an argument with your wife, Sarah Gesink?
Yes.
And during the course of that argument, did you push her?
Yes.
And you did not push her in self-defense, correct?
Correct.
Okay. I believe that would establish a basis, Your Honor.
You provided me with the basis to accept the plea. I will do so. In regard to sentencing, is there anything you wanted to state on this, Mr. Woolery, or just rely on your recommendation for diversion?
Yes, Joe. Recommendation is good. Thank you.
Very good. Mr. Half, you wish to allocate?
Yes, Your Honor. I think my client is a good candidate for the diversion program here. He's remorseful about what happened. He's going to use this to better himself and make him a better person and a better husband. So we would ask you to follow through with sentencing him on the diversion and just ask for that fines and costs and to lift the no contact order. Thank you.
Well, I mean, lifting the no contact order is a different thing there. That's not, is that something that was envisioned, Mr. Woolery? Normal process on diversion is to have the no contact adjusted after a period of counseling. But if you've agreed to that in the underlying agreement, I'm fine to adjust it.
I don't think we discussed that. I mean, Mr. Half, if we need to go in a breakout room, but We didn't have
What
to
I-
specify, correct?
What I normally do
Yeah.
on these matters, and that is something that would obviously need very specific approval by the victim. So, well, the process on this is to engage with the probation, and they would make a recommendation to me based on their discussions with Mr. Gessin and probably their conversation with the victim as well.
Okay, my client will go through that process, Your Honor.
It should be fairly quick if there's not going to be any issue, but other than that. All right, so Mr. Gessin, do you have the number for probation?
No.
The number is, you can just punch it into a phone quick because you're going to be dialing it as soon as you hang up with me.
Okay.
And when you
Okay,
call there, just call there and tell them that you've been placed on diversion and they'll take it from there, okay?
Okay, thank you.
Good luck to you. You can leave the court. Anything else, Mr. Half?
No, Your Honor, have a good weekend.
You too. Take care. You're all set. You can leave the court, Mr. Gessin. Good luck to you.
Yep, thank you. Thank you for your time.
All right. Ms. Strasser, are you ready to proceed?
Yes, we can proceed with Mr. Ferris. He's entering a plea under the diversion statute.
Hello, Your Honor. Can you hear me?
I can. 1 second, sir.
Yep, take your time.
Thank you. Let's go on the record in the matter of the People's State of Michigan versus Spencer Ferris, file 240333SM. Let's have appearances.
Mark Roller for the people, Your Honor.
Tess Strasser on behalf of Mr. Ferris.
And Mr. Ferris, would you state your name, please?
Yes, Spencer Ferris.
Mr. Ferris, okay. Ms. Strasser, you want to state your understanding, please?
Yes, he intends to plead guilty under the diversion statute.
And is this a matter where we have victim notice or do you need to set sentence in? Mr. Woolery.
Judge, can we please set this?
Yep. All right. So, Mr. Ferris, you understand what your attorney stated. Is that your understanding as well, sir?
Yes, Your Honor. I also was hoping, and I don't know if we could do this today. I know my lawyer did speak with my mom the other day, as this occasion was with a family member, you know, a loved one. I do care about my mom.
And I'm not trying to be rude. What I am trying to do, though, is make sure that we get through the aspect of the specific plea first. I don't want you to make any statements. We're on the record right. We're on the record right now, and I don't want you to make a statement that may in some way imperil your ability either to make that plea, or if you're not able to make the plea, I don't want it to be something that you state on the record that might impinge on your ability to fully defend yourself. Okay, so let's just get through this process.
Okay.
And if you want to make any other statements, we'll wait for you to at least review them either with your attorney or in allocution after the plea. Okay.
Okay. Yes, Your Honor. Thank you.
In other words, stop talking about your case, please.
Thank you.
Now, this is, you understand, sir, you have a right to proceed to trial. And if you did proceed to trial, the prosecution would have to prove you guilty of each of the elements of the charge against you beyond a reasonable doubt.
Yes, sir, Your Honor.
You understand that by virtue of taking this matter, if you take this matter and make a plea here today, that means that there's not going to be a trial. You're going to be telling us that you're guilty of this matter and there will be no trial. Is that your understanding and is that your intention?
Yes, Your Honor. Yes, sir.
Has anyone tried to frighten you or force you into doing this?
No, sir.
Has anyone made any promises to you that I am not aware of?
No, sir.
Are you a citizen of the United States?
Yes, sir.
Are you currently on probation or parole for any other criminal convictions?
No, Your Honor.
Ms. Strasser, you want to articulate a basis of the plea?
Yes, Mr. Ferris, on January 25th, 2024, were you in Allegan City, Allegan County?
Yes.
Were you at home with your mother, Lorraine Montgomery?
Yes, correct.
What happened on that date?
Basically, and the best way I could really explain this is, you know, I kind of do have a history of having a bit of anger management, you know, myself. Really just, you know, I've already went through therapy. I did 2 years of therapy back in 2018.
Let's try to focus it in on the date of the incident, sir, and then we can get into history and
Okay.
How we're gonna move forward going
All
forward.
right, so could you just repeat the question
Yes,
again?
so
'Cause it-
on January 25th, were you in an argument with your mother and Lorraine
Yes.
Montgomery?
Yes, I was.
And then as a result of the argument, did you push or shove her in some way?
Oh, yes, correct.
And that wasn't in self-defense, that was an assaultive shove?
No, it was just unintentional. I shouldn't have done it. It was, but yes.
Yeah.
Well, when you say unintentional, you meant to do it. You just you didn't necessarily mean it as an assault, but it was a non
Right, exactly,
intentional-
Your Honor,
pushed
yes.
her against her will. Is that correct?
Yes, yes.
Very good. Please proceed, Ms. Strauss.
I am satisfied with the plea. I believe he did make a factual basis.
And you, the location of this incident, did you say that was the city of Allegan?
Yes.
Sir, you provided me with the basis to accept the plea. I will do so. What we need to do here, sir, is to set the matter for sentencing because we do need to have victim notice on this matter. They don't have to appear. They don't have to identify any testimony to us, but we have to at least give them that opportunity. So what we'll do is we'll just set the matter for a plea on a different date, and there shouldn't be anything that should interfere with the resolution as you've already identified it. All right?
Yes, Your Honor.
All right, we're all set then. You can leave the court. If you have any questions, follow up with Ms. Strasser, okay? You understand, Mr. Ferris?
Yes. So, I kind of had like a couple questions.
I can
Or do you
contact you and we can go over
Tell you
them.
what, we
Okay.
can go ahead and So are you going to be able to call him right now, or do you want to break out? Right
Yes, I'll call you right now, Mr. Ferris. You were my last
Right.
case.
Okay,
now?
thank
You
you.
can leave the court, Mr. Ferris.
Thank you, Your Honor. Have a great day.
You too. Ms. Silverstein.
Yes, Your Honor, I'd like to address bond for Mr. Voit. He's in custody.
Okay. All right, let's go on the record in the matter of People State of Michigan versus Jeffrey Voit, file 232708. Have appearances.
Mark Woolery for the people.
Mariah Silverstein appearing on behalf of Mr. Voit.
Mr. Voit, would you state your name, please?
Jeffrey Voit.
All right, and Ms. Silverstein.
At this time, we ask bond be amended back to a PR bond. Mr. Voit is currently in custody on a cash surety bond for missing a previous court date. He's been incarcerated since March 14th. He served a couple of days in jail already. He understands the importance of making it to his next court dates, being more diligent in checking the mail and being more responsive on his phone. He will be doing drywall work upon release. I've reached an agreement with the prosecutor's office where we're requesting an adjournment so that he can complete some drug treatment courses in exchange for a plea to a reduced charge. So we're asking he be allowed to be back in the community so he can get a jump start on those treatment courses, get back into work. And so then he can successfully enter a plea to a reduced charge after that period. So we ask bond be changed back to a PR bond at this time, Your Honor.
Mr. Woolery?
We have no objection, Your Honor.
What's bond currently situated at?
I believe it's 2,500 cash or surety.
There's a no contact order already identified on the file, correct?
Yes, that's my understanding.
And your client does have a separate place to reside?
Yes.
Mr. Voigt, I am going to adjust bond to $2,500 personal recognizance. Understand no contact will continue in this matter. If you violate the no contact order, sir, please understand I will not hesitate to revoke bond and reestablish bond at a higher rate than $2,500 cash or surety. Do you understand that?
Yes, Your Honor.
You agree to comply with the no contact order?
Yes.
Contact order, just so we can just cut through all of these now I understands later. No contact means you're not to have contact of any kind. If she calls you, you don't answer it. You understand that?
Yes, I do.
You understand that if she sends you a text message, you don't respond to that. You understand that?
Yes, sir.
You understand if she pulls up next to you on the street and asks you to get in the car, you don't get in the car. You remove yourself from that situation.
Yes, sir.
You have no contact of any kind. Is there any question you have of any manner, way, shape, or form?
No.
Your Honor, just for clarity of the record, it's a he. The other party is Mr. Voigt's father.
Then let me take it back to he. Any pronoun, it can be, regardless, no contact of any kind means no contact of any kind.
Yes, I understand.
All right, you're all set. You can leave the court. Well,
So we had the guy that assaulted his mother, and now we have someone who's assaulted his father. Can y'all please have a little respect for your parents? Seriously.
Mr. Voigt, you're all set. You're done.
Thank you.
Ms.
Thank you,
Silverstein,
Ron.
you're welcome.
We can proceed with Miss Johnson.
Let's go on the record in the matter of People State of Michigan versus Johnson and appearances.
No,
Right.
Mark Woolery.
Sorry.
Go ahead. Go ahead.
Mariah Silverstein appearing on behalf of Miss Johnson.
Mark Woolery for the people, Your Honor.
Good. Ms. Johnson, can you hear me?
Yes, I can.
Will you state your name, please, for the record?
Tamir Johnson.
Very good. Ms. Silverstein, you want to state your understanding on the record, please?
At this time, Miss Johnson will be entering a plea of guilty to retail fraud, third degree. It's my understanding the people are recommending HIDA, and we'd be asking for HIDA as well.
Okay, and this is going to be plea to charge or to a reduced, or what are we doing?
Reduced to retail fraud third. I believe it's charged as a second right now.
Ms. Johnson, you heard what was stated. Is that your understanding?
Yes, I'm trying to find a way to get this off my record and stuff like that. So I'm trying to do
Hold
the
on.
HIDA program.
Let's go. Before we get to HIDA, we got to go through the questioning process of establishing this plea, all right?
Okay.
You understand that the resolution that Ms. Silverstein has negotiated on your behalf?
Yes.
You understand, ma'am, you have a right to a trial, and if you went to trial, the prosecution would be obligated to prove that you're guilty beyond a reasonable doubt of each of the elements of the charges brought against you.
Yes.
You understand if you make a plea here today to this lesser charge, you're going to be telling us you're guilty of the retail fraud third degree, and the people are going to be dismissing the retail fraud second degree, but there will be no trial. Is that your understanding, and is that your intention?
Yes.
Has anyone frightened you or forced you into doing this?
No.
Has anyone made any promises to you that I'm not aware of?
No.
Are you currently on probation or parole for any other criminal convictions?
No.
Are you a citizen of the United States?
Yes.
Ms. Silverstein, you wish to articulate a basis for the plea?
Yes, Your Honor. Miss Johnson, on December 24th, 2023, were you at Walmart in Allegan County?
Yeah.
And when you were there, did you take property that was offered for sale?
Yes.
And did you move that property and take it out paying for it?
Yes.
And I believe that and was that property valued less than $200?
Yeah, way below that.
Okay. I believe that is a factual basis.
You provided me with the basis to accept the plea. I will do so. In regard to sentencing Mr. Woolery, other than HIDA?
No, Judge.
Ms. Silverstein?
We asked the court sentence Ms. Johnson to the HIDA program. She's hoping, she's finishing her prerequisites to enroll in a nursing program, and she wants to take steps to get this off her record. She takes full responsibility for her actions. She was trying to get her son a present for Christmas and didn't have money to afford it. She recognizes that is no excuse, but that this was out of character for her, and she's ready to move forward and take advantage of this HIDA program.
All right. What would you like to say, Ms. Johnson?
Yeah, basically what she just said, that I'm really just trying to get this off my record. It's kind of hard getting a job and also being a single mom and stuff like that. I had made a huge mistake, something that I wouldn't do again at all. I'm just trying to find a way, if there is a way, to get this off my record, because this is the first thing I ever did in life. I never even had police contact. So, yeah, I just want to move forward and do what's best. That's all.
All right. What I'll do is I'll place you on probation for a period of 6 months. There's a $180 oversight fee associated with that. That's going to be pursuant to the HIDA probation. Upon successful completion of the full term of the probationary period, this matter may be removed from the public record. Fines are going to be $200. State costs $50. Court costs $200. Grand victim right fee of $75. For a total of $705 over the period of probation. Do you have the number for probation, Ms. Johnson?
Yes. She just sent it over to me.
Okay. All right. You're both saying the same thing. Is there anything else you wanted on the record, Ms. Silverstein?
And no, I just wanted to make sure she receives the number, and it sounds like she did. So thank you, Your Honor.
All right. Ms.
Yes,
Johnson,
thank
you're all set. You can call the probation department right now. They'll be getting this, well, as soon as I make this click, they now have it. So you're all set. Give them a call and tell them what's going on, and they will work with you from there.
All right. Thank you so much.
You're welcome. Good luck to you, man. All right.
You know how I got something off my record once? When I thought about doing it, I didn't do it. It never went on my record. I mean, that would just be my advice.
Right, Ms. Strasser or Ms. Silverstein, we have a number of people. Oh, who's the iPhone? Let's find out who that iPhone is. Well, whoever it is isn't connected. The other individual, oh, there they are. The individual on the iPhone, can you tell me your name, please? You're muted. You need to unmute yourself. The individual just signed into court from the on the iPhone. Please tell me your name. Unmute yourself and tell me your name. Your camera's off. Oh, there you are. All right, what's your
There
name?
we go. Sorry about that. Spencer Ferris again. Sorry,
Oh
sir.
God, he's back.
Oh, Mr. Ferris. Okay, did you need to speak to your attorney?
Your Honor,
Um,
we're actually
yes.
requesting at this time to amend the no contact order to non-assaultive contact. I did speak with the alleged victim, his mother, Lorraine Montgomery, yesterday, and she informed me she has no problem with him coming home, as she does have stage 4 lung cancer and can use help with the treatment program.
Mr. Woolery, any objection?
No objection, Judge, based on Ms. Strasser's conversation with the victim.
All right, let me go back to that. Ferris. This is one we did not sentence. We just indicated that we were going to set for victim notice, correct?
Yes,
Yes.
All right, that's fine.
thank you.
Mr. Ferris, you're all set. You can leave the court.
All right. Thank you, Your Honor.
You're welcome.
You have a great day.
You too. All right.
All right, indeed, Judge. The other couple that were on there, they were just easy peasy click through ones that didn't really have any entertainment values, so I didn't include them. I'm sorry. But that's what I got for you tonight. We had a whole lot of fun in chat, and it seems everybody is gone tonight. Which is okay, as long as y'all hit the like button first. I encourage sleep streaming. It was yummy. I love me my garlic bread. I am a garlic addict. I swear, I've been craving it. Like, I can't have enough garlic. Actually, I knew a girl. She used to eat the toes of the garlic raw and whole. I mean, well, she chewed them, and when she ran, she like would go running every morning, and when she'd come home, like she would sweat garlic. It would come out her pores. She loved it that much too, but luckily I don't do that. I know. It's good stuff. Good stuff. Garlic is amazing. And it's supposed to be good for your heart. And, I've had a couple EKGs recently, so there's proof that there is one in there. Oh. I love Bram's Lullaby. I had to reread that a couple times there. That one line. Well, she was engaged to my brother for a minute. Oh, I love you, Marquise Phillip. I'll say hi to you. Because I don't have to type it. That's why I need to eat the garlic. I got to keep it in tip-top shape. PG, parental guidance suggested. Well, I'll have to make some more sometime. I'll get around to it. But for tonight, none-night. It's none-night time. Thank you guys for so many laughs and so much fun. And Bad Scooter, thank you so much for the Dutch oven. I love it. And I am so, so grateful. A Zoom band. I've seen those. There's a group of singers that do some of the sea shanties that I love. And like they've done Hoist the Flag and of course the Willow Wren and other ones like that. And I love them. They're especially the bass. Oh, his voice. So deep. So deep. It's so nice. Uh-oh. Gotta take care of that. He picked you. Love all of you, every one of you. All right, guys. Be safe, be well, sleep sweet, and much love.